Picture this. You're a financial advisor in Ontario. Your client just passed away. You've got a life insurance policy in one system, property records in another, investment accounts in a third, and the actual will document? That's in a binder somewhere. Or maybe an email from 18 months ago.
And the family is calling you asking who gets what, and you're frantically trying to reconstruct the entire estate plan from 7 different sources. I've heard this story so many times.
Right, and here's the wild part. We're talking about firms managing millions, sometimes tens of millions in client assets. And they're doing this with tools that haven't evolved since the early 2000s. So today we're looking at a platform called The Ledger that's trying to fix this. And we're going to talk about why estate planning technology in Canada has been so broken for so long.
And why Canada specifically matters here, because I think that's something people overlook. They assume estate planning software is estate planning software, but Canadian law is genuinely different in ways that most tools just don't handle.
Let's start there. What makes Canadian estate planning different enough that it needs its own platform?
Okay, so first, account types. Canada has TFSAs, RRSPs, RRIFs, RESPs. These aren't just different labels for the same thing. They have completely different tax treatment, different beneficiary designation rules, different implications for probate. A TFSA passes tax-free to a named beneficiary and bypasses the estate entirely. An RRSP has deemed disposition rules at death that can trigger a massive tax bill if it's not set up correctly.
And most US built tools don't even have fields for these account types, right?
Exactly. They bolt it on as an afterthought, if at all, or they just give you a generic retirement account category and expect you to track the nuances in your head, which defeats the entire purpose of having software in the first place.
What about probate? Because I know that's structured really differently province to province in Canada.
Yes. So Ontario charges estate administration tax, most people still call it probate fees, at about 1.5% on estate value above $50,000. Alberta has a flat fee schedule that caps out around $500, regardless of estate size. Quebec doesn't charge probate fees at all for notarial wills. BC, Saskatchewan, Nova Scotia, they all have their own formulas.
So if your software doesn't know which province the client is in, it can't calculate accurate probate costs.
Right. And probate cost modelling is a huge part of estate planning conversations. Clients want to know, should I put my kids on the title of my house to avoid probate? Should I set up a trust? Should I shift assets into joint accounts? You can't give good advice if your software is spitting out numbers based on US federal estate tax assumptions.
So, the Ledger built this in from the start? Probate fee rates for all 13 provinces and territories?
Yep. It's core to the platform, not an add-on module. And they also have a US mode you can toggle on, which matters because a lot of Canadian practices have cross-border clients. Snowbirds, dual citizens, people with property in Florida or Arizona. So you're not locked into one system or the other.
That actually brings up something I've been curious about. Most estate planning tech is built by software people who interview a few lawyers and then build what they think advisors need. The Ledger was built with a practicing estate planning expert, right?
Yeah, not just consulted, actively involved. Every feature gets tested by someone who's doing this work day to day. So the workflow reflects actual pain points, not a product manager's best guess about what an advisor's day looks like.
Give me an example of a feature that came out of that process.
The document pipeline. So in real life, a will doesn't just get drafted and then it's done. It goes through stages. You draft it, someone reviews it, the client signs it. Maybe it gets notarized depending on the situation. Then you store the final version. Most software treats this as a binary. The document exists or it doesn't. The Ledger has a 5-stage pipeline: draft, review, signature, notarized, final. So nothing falls through the cracks.
That sounds simple, but I can see how it would prevent the nightmare scenario where you think a will is finalized, but it's actually still sitting in review.
Exactly. And each stage can have different people responsible for it. The advisor drafts, the lawyer reviews, the client signs. Everyone sees their part of the process and nothing else.
Wait, so role-based access is built in?
Yeah, advisors see the full client profile. Lawyers might only see the legal documents they're reviewing. Clients see their own information but not the back end calculations or other clients' data. It's not just about privacy, though that matters. It's about reducing cognitive load. People see what they need to act on, not everything.
That makes sense. Let's talk about the AI piece because I know there's a will drafting feature that uses AI, and I'm curious how that actually works without just generating garbage.
So the AI assisted will draft generation reads the full client profile. It knows their assets, their beneficiaries, their family structure, their account types. It's not starting from scratch, it's working with real data that's already in the system. Then it produces an editable first draft in seconds.
Editable being the key word.
Yes, this is not a finished legal document that you just print and sign. It's a starting point. It gets you 80% of the way there so you're not staring at a blank page. A lawyer or advisor still reviews it, adjusts it, makes sure it reflects the client's actual intentions. But you're not retyping boilerplate clauses for the 50th time.
Okay, so it's more like autocomplete for wills than full automation.
That's a good way to put it. And because it's pulling from the client's actual data, it's less likely to have inconsistencies. If you've listed 3 beneficiaries in the system, the draft will reflect all 3. You're not going to accidentally leave someone out because you copied an old template.
What about document storage? Because I imagine there are compliance and security concerns when you're dealing with wills, powers of attorney, all these sensitive files.
Huge concerns. The ledger uses secure client document storage with signed URLs, which is bank-level file handling. It's not a shared Dropbox folder where anyone with the link can access everything. Each document has a time-limited, one-time access URL. And the architecture uses row-level security, meaning every client's data is isolated at the database level, not just in the user interface.
So even if someone somehow got into the system, they couldn't just pull all client records?
Right. Each row is locked down. It's a more robust security model than a lot of legacy platforms that just rely on login credentials and UI permissions.
Let's talk about the invite system because I saw they use something called magic links. What does that actually mean in practice?
So, when you need to bring a lawyer or a client into the system, you don't make them create an account with a username and password and go through some clunky onboarding flow. You send them a magic link, they click it, they're in. They see exactly what they're supposed to see based on their role, and they can take action immediately.
That's a friction point I never thought about. But yeah, every extra step you add to the process is another opportunity for someone to not follow through.
Especially for clients. You send someone a link that says, create an account, verify your email, set a password, agree to terms of service, and they just won't do it. Or they'll do it 3 weeks later after you've followed up 6 times. Magic links eliminate that entire problem.
Now I want to shift gears a bit and talk about the business model because I think it's actually pretty clever. It's not a flat SaaS fee, it's per estate pricing based on estate value, right?
Yeah, fixed fee tiers that auto-calculate from gross estate value. So a small estate might be in one pricing tier, a $2 million estate is in another, a $10 million estate is in a higher tier. The pricing scales with complexity.
Why does that make more sense than a flat monthly subscription?
Because estate planning work isn't uniform. If you're a boutique firm that handles 3 or 4 estates a year, you don't want to pay the same subscription fee as a firm that handles 50. And if those 3 estates are high net worth and complex, you can afford to pay more per estate than someone dealing with simpler, smaller cases. It aligns cost with value.
So it doesn't punish small firms for existing.
Right. A flat SaaS fee basically subsidizes big firms at the expense of small ones. This model is more equitable.
Okay, let's zoom out for a second. Why does any of this matter right now? Why is estate planning technology suddenly urgent?
Because we are in the middle of the largest generational wealth transfer in human history. Baby boomers are aging. Trillions of dollars are moving from one generation to the next over the next couple of decades. And the advisory industry is not prepared for this operationally.
What does not prepared look like?
It looks like what we described at the top of the show: binders, spreadsheets, email chains, manual calculations. Advisors spending hours reconstructing estate plans because there's no centralized system. And meanwhile, the clients who are inheriting this wealth expect a digital experience. They expect transparency. They expect to be able to log in and see their documents, track their assets, understand the plan.
And if the firm can't deliver that experience, the client goes somewhere that can.
Exactly. This is an existential issue for advisory firms. If your tech stack is stuck in 2005, you're going to lose the next generation of clients.
Now, I want to bring in something from the research we looked at, because there's a common misconception about Canadian estate law that I think is relevant here. A lot of people assume that if you're in a long-term common law relationship in Ontario, your partner automatically inherits if you die without a will. That is not true.
This shocks people every single time. Under Ontario's Succession Law Reform Act, a common law partner gets zero under intestacy rules. It doesn't matter if you've been together for 20 years. It doesn't matter if you have kids together. It doesn't matter if you share a mortgage. If you die without a will, your common law partner is legally a stranger to your estate.
And this is different from some other provinces, right? BC treats common law spouses differently after a certain period of cohabitation.
Right. BC and a few other provinces recognise common law partners for inheritance purposes. Ontario does not. So people move from BC to Ontario, or they hear about the rules in another jurisdiction, and they assume it's the same everywhere. It's not.
What can a surviving common law partner do if this happens?
They can make a dependents relief claim under Part 5 of the Succession Law Reform Act. Basically, they can ask a court to order support from the estate if the deceased had an obligation to support them. But this is a court process. It's adversarial, it takes time, it costs money, and the outcome is not guaranteed.
So it's a safety valve, not a solution.
Exactly. And it doesn't give your partner what you would have left them if you'd just written it down in a will. This is why a will is not optional for common law couples in Ontario. It's the only legal mechanism that actually gives your partner inheritance rights.
And this is where estate planning software actually matters, right? Because if the platform is built around modern family structures, common law partnerships, blended families, multiple beneficiaries across different asset types, it prompts advisors to have these conversations before it's too late.
Yes. A good system should surface these issues. It should flag when a client is in a common law relationship and doesn't have a will. It should ask about beneficiary designations on registered accounts. It should model what happens under intestacy rules versus what happens under the current plan. If the software is just a digital filing cabinet, it's not doing its job.
Let's talk about probate for a minute, because I think there's a lot of fear around probate that isn't always justified. What do people get wrong about probate in Ontario?
First, people think probate is this catastrophic expense that you have to avoid at all costs. In Ontario, the estate administration tax is about 1.5% on estate value above $50,000. On a $500,000 estate, that's roughly $6,700. On a $1 million estate, it's about $14,000. It's real money, but it's not the end of the world.
And probate isn't always required, right?
Correct. Assets with named beneficiaries, life insurance, RRSPs, TFSAs, RRIFs, pass outside the estate and don't go through probate. Jointly held property with right of survivorship passes directly to the surviving owner. So if your estate is mostly registered accounts with beneficiary designations and jointly owned real estate, probate might not even be a factor.
But financial institutions usually require probate before releasing assets held in the deceased's name alone.
Right. Banks, investment firms, the Land Registry Office, they want to see a certificate of appointment of estate trustee before they'll transfer significant assets. So for most estates with any kind of complexity, probate is unavoidable. The question is not whether you can avoid it, but whether the strategies you use to try to avoid it create bigger problems.
Like what?
Putting your kids on the title of your house to avoid probate. This is a classic mistake. Yes, it means the house passes outside the estate when you die, but it also means you've given away partial ownership while you're still alive. Your kid could get divorced and their spouse could claim an interest in the property. Your kid could get sued and the property could be subject to creditors. You've lost control.
And there can be capital gains tax implications too, right?
Yes, if it's not your kid's principal residence, they could owe capital gains tax when the property is eventually sold. So you save $14,000 in probate fees and create a $50,000 tax bill down the road. These are the trade-offs that good planning software should help you model.
Which brings us back to the ledger. If it's modeling deemed disposition on registered accounts, probate fees by province, capital gains on real property, all of that in one system, you can actually see the full picture.
Right. You're not optimizing for one variable in a vacuum. You're looking at the whole estate and making informed decisions.
There's another legal change in Ontario that I think is worth mentioning. Virtual witnessing for wills. This became permanent in 2021, right?
Yes. During the pandemic, Ontario allowed wills and powers of attorney to be signed with witnesses attending by video conference rather than in person. That was temporary emergency legislation. But in 2021, they made it permanent through amendments to the Succession Law Reform Act.
Why does that matter?
Because one of the big friction points in estate planning is logistics. You need the testator and two witnesses in the same place at the same time. If one of those witnesses lives in another city, or if the client has mobility issues, or if you're just trying to coordinate schedules, that can drag the process out for weeks or months. Virtual witnessing eliminates that barrier.
But there's still a formal process, right? It's not just sending a PDF around.
Correct. The witnesses need to be able to see the testator sign in real time. There's a specific procedure involving countersigning. It has to be done properly or the document isn't valid. Not all lawyers offer this service, and you can't just wing it. But it is a legitimate and permanent option now.
Okay, last legal quirk. Marriage used to revoke a will in Ontario. That changed recently too.
Yes. Before January 1st, 2022, getting married in Ontario automatically revoked any existing will. The logic was that marriage is a significant life event that might change your intentions. But in practice, it meant that people who got married without updating their wills died effectively interstate, which was often not what they intended.
So now marriage doesn't revoke a will.
Right. But that doesn't mean your existing will is correct for your new circumstances. If your will was written before you married and doesn't mention your spouse might not be adequately provided for even though the will itself is still valid. You still need to review and update your documents after major life events. The change just means the will doesn't automatically self-destruct.
So the law is becoming slightly more forgiving of people who don't update their documents immediately. But it's still not a substitute for actually keeping your plan current.
Exactly, and this is another area where software can help. If the system knows a client got married and their will was drafted before the marriage, it can flag that for review. It doesn't have to rely on the advisor remembering.
All right, I want to bring this back to the big picture. We've talked about the technology, the legal quirks, the generational wealth transfer. What's the actual call to action here for someone listening who works in this space?
If you're an advisor or a lawyer doing estate planning work in Canada, the question you need to ask yourself is, am I using tools that reflect how my clients actually live and how Canadian law actually works? Because if your software doesn't know what a TFSA is, doesn't know that common law partners don't inherit under Ontario intestacy rules, doesn't model provincial probate fees, you're building your advice on a foundation that doesn't match reality.
And the risk is not just operational inefficiency. It's giving bad advice because your tools are giving you bad data.
Right. And as the wealth transfer accelerates, the clients who are inheriting expect better. They expect transparency. They expect digital access. They expect you to have a system that doesn't require you to email them a PDF and ask them to print it and mail it back.
So platforms like the Ledger are not just nice-to-have productivity tools. They're becoming table stakes for staying competitive.
I think that's right. And the firms that recognize this early are going to have a significant advantage over the ones that wait until they've already lost clients to someone with better infrastructure.
Final thought. If there's one thing you want people to take away from this conversation, what is it?
Estate planning is not a static document. It's an ongoing process that reflects life changes, legal changes, family changes. Your technology should support that process, not just store the output. And in Canada, that means the technology has to understand Canadian law from the ground up, not as an afterthought.
Well said. Thanks for walking through this with me, Ellie. I think we covered a lot of ground today.
Thanks, Alex. Always a good conversation when we can dig into both the tech and the legal nuances. I think people forget how intertwined they are.
Agreed. All right, everyone, that's our show. If you're working in estate planning in Canada and you want to see how modern infrastructure can change your practice, take a look at the Ledger. We'll link to it in the show notes. Thanks for listening.
See you next time.